Political question doctrine. Political questions are those questions which, under the Constitution, are to be decided by the people in their sovereign capacity, or in regard to which full discretionary authority has been delegated to the legislature or executive branch of the government. The term political question connotes a question of policy. It is concerned with issues dependent upon the wisdom, not legality, of a particular measure. So the political question doctrine prevents the court from deciding cases that are of a political nature and leaves the decision to the elected officials of government. In other words, the court, through the political question doctrine, defers to the judgment and discretion of the executive and legislature, matters that involve policy, because they are the people's elected officials and hence are more directly accountable to them. The 1987 Constitution, recognizing the importance of the court's active role in checking abuses in government, relaxed the political question doctrine and made it a duty upon the court to determine whether there had been abuses in the government's exercise of discretion, and consequently nullify such actions that violate the Constitution, albeit in the narrow and limited instances of grave abuse of discretion. Thus, when a government agency's exercise of discretion is so grave as to amount to an excess or lack of jurisdiction, it becomes the duty to step in and check for violations of the Constitution. In these instances, the political question doctrine cannot prevent the court from determining whether the government gravely abused its discretion against the backdrop of the Constitution. Two species of political questions. First, a truly political question, and another is not truly political question. Truly political questions are those questions which, under the Constitution, are to be decided by the people in their sovereign capacity. Truly political questions are beyond judicial review with the due deference with the doctrine of separation of powers. How about not truly political questions? These are questions in regard to which full discretionary authority has been delegated to the legislative or executive branch of the government. It may be reviewed by the courts. The determination of a truly political question from a non-justiciable political question lies in the answer to the question of whether there are constitutionally imposed limits on powers or functions conferred upon political bodies. If there are, then our courts are duty-bound to examine whether the branch or instrumentality of the government properly acted within such limits. In the case of the Diocese of Bacolod versus Comelec, the court held that when petitioners, a diocese and its bishop, posted tarpaulins in front of the cathedral, which aimed to dissuade voters from electing candidates who supported the RH law, and the Comelec twice ordered the latter to dismantle the tarpaulin for violation of its regulation, which imposed a size limit on campaign materials, the case is about Comelec's breach of the petitioner's fundamental right of expression of matters relating to election. The concept of a political question never precludes judicial review when the act of a constitutional organ infringes upon a fundamental individual or collective right.